Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Nick Esterbauer.
And I'm Megan Zanette.
Welcome to Hull on Estates. You're listening to episode number 713. And today we're going to be talking about the legal and practical impact of probate. But first, how are you doing today, Megan?
I'm good. How are you?
Good, making the most of this unpleasant weather. It's a bit dark outside, as our viewers can see behind us. So a good time to think about probate, which is something we deal with
Every
daily
day
on our files. And it's a concept and a term that gets thrown around quite a bit. So we thought we'd maybe start off by talking a little bit about what is probate, what does it mean, and then we'll take a look at a new interesting court decision that considers, okay, what does this mean from the perspective of what can be done after probate is granted and what might be prohibited after probate is granted because of the legal impact of that act. So
Absolutely.
I think a good place to start out is we often refer to the term probate when we talk about a grant of probate and also the process of applying for a grant of probate. Now, the actual legal term for probate is a certificate of appointment of a state trustee. In the past, we distinguished between a certificate of appointment of a state trustee with a will versus a certificate of appointment of a state trustee without a will. But starting off with a certificate of a state trustee, I can't even say it right. It's a lot of words. A certificate of appointment of a state trustee in circumstances where there is a will. The process of applying for a grant of probate and when that certificate is issued, what that means is the court is confirming the authority of the estate trustee named in that will to act and confirming the validity of that will. And it's typically something that's needed for the purposes of dealing with third parties, maybe financial institutions, if there's real property that needs to be transferred or sold. But the authority of the estate trustee still is derived from the will itself, because the court really is looking at that will and saying, yes, this is valid. Yes, third parties are safe relying on the authority that's granted under it and even the terms of the will itself. Now, a certificate of appointment of a state trustee in circumstances where there is no will, someone's died intestate, and that's the only circumstances where you can apply for probate without the will, if there is actually no will.
Right.
Because the application materials require the applicant to swear or affirm that they've made efforts to locate the will and there isn't one, and they've contacted the lawyer perhaps that the deceased might have used, and nothing has been found. And in those circumstances, before probate's issued, no one is authorized to act as a state trustee because there's no will that's naming them. So the authority of the estate trustee in those circumstances is derived from the grant of probate itself and confirms that this person is authorized to act as a state trustee and take steps to administer the estate. Once those grants have been made, the impact in a lot of ways is similar, but we've got situations where we've got a will and situations with no will, and probate often does come into play regardless of the scenario, whether there's a will or not.
Absolutely.
So, Megan, why don't you take us through this decision, the Cooke Family Trust decision? It's the citation for our listeners is 2025 ONSC 370, and it's an interesting decision that looks at the actual practical implications of probate having been granted on relief that parties might be able to seek after that grant has been made.
Absolutely. And for those who are interested, I've also written a blog on this. You can have a summary of the more detailed facts in written form. But in brief summary, essentially, a deceased passed away testate, so he had a will. But unfortunately, the will had a bit of a gap in terms of one of these circumstances that could take place if the deceased spouse had predeceased or survived to be deceased. And in that scenario, when the deceased son, who was appointed the estate trustee under the deceased will, applied for probate, all of the beneficiaries were served and no one raised any objections when they received the probate application. However, later on, once the certificate of appointment of a state trustee with a will, as Nick just described, was actually received and granted by the court. About 2 years later, one of the deceased's other children initiated an action.
Something I found interesting too, Megan, was that this was more than 2 years after the deceased person had passed away as well. So quite a bit of time had passed between date of death and when this litigation was actually commenced.
Absolutely. So it was about 2 years from the deceased death when the action was first initiated, and that was already quite a while after probate had been granted and steps had already been taken in the administration of the estate. And essentially what the deceased child who initiated the action was arguing was that there was a gap in the deceased's will that didn't represent the deceased's true testamentary instructions. And in turn, they were trying to bring a negligence action against the drafting lawyer. And I'm not sure if you want to add anything with facts before we go on to what the court decided.
Yeah, so I think what was interesting here was that looking at the will, there was potentially an interpretation issue, and maybe an issue that was capable of being rectified. But as you mentioned, Megan, at the time that the probate application was submitted, no one did anything. None of the beneficiaries objected to the appointment of the estate trustee under the will and the validation of that will. And typically when we're acting for clients, especially on a will challenge, we're going to be recommending that they file what's called a notice of objection to the issuance of the certificate of appointment with the court to make sure that that grant of probate is not issued that may restrict or make it more difficult for clients to take steps to challenge the validity of the will or to raise issues regarding possible gaps in the will. Because essentially when the probate application is processed and when the court approves that will, it's confirming that the deceased person, that the testator, had knowledge of and approved of the contents of the will. And really what was happening here was there was a bit of an attack on the validity of the will from that perspective, because the plaintiff or plaintiffs were arguing that the deceased did not or could not have had knowledge and approval of some aspects of the will.
No, that's exactly it. And that's exactly what the court ultimately decided. So they discussed some of the factors that Nick just went through and, re-emphasize that when probate is served on beneficiaries and ultimately granted, that it's not just the authority for the estate trustee to act, but it is also that validation and verification that the deceased's last will that's presented to the court truly represents the testamentary instructions.
It's an in rem determination. That's what we say. It's in rem because it affects third parties as well.
Yep.
For example, the financial institutions, the land titles office, and so on.
Absolutely. And here specifically, so in relation to the actual action, which was really founded in a negligence claim, the court found that the negligence action would be a collateral attack on the certificate of appointment that had been granted. And, as you mentioned, that really what the proper course of action would have been is for the beneficiaries who since had initiated the negligence claim to really have objected when they received that probate application and brought forth that issue then, and perhaps brought an application for rectification, which could have, resolved the gap in the deceased will at the time that probate was being debated.
Yeah, so it's an interesting, I think you probably mentioned this already, Megan, but this was a motion for summary judgment. So summarily, the negligence action was dismissed because probate had already been granted.
Yeah, so the defendants actually brought the motion because, they were in the position that Nick just mentioned where, we already have this order that's granting the validity of the document and the estate trustee's authority to act. And so ultimately the negligence claim was dismissed.
Yeah, so I think it's an interesting decision. It is helpful definitely to lawyers like us who do some work for Law Pro defending other lawyers, because we can look at, okay, whether or not probate was issued, and that may assist as a defense to negligence action that's brought with respect to the validity of a will or necessity of rectifying the will after probate's been issued. And it's interesting as well because really I think it's consistent with what we like to tell our clients, which is if there's a concern about the will, best course of action is to do something about it quickly, whether that's filing a notice of objection or bringing a court application for directions of some sort. You don't want to sit and wait until it might be too late to do so because probate's been issued or some other reason relating to the passage of time.
Yeah, absolutely. And that's what the court actually really concluded the decision with that, bringing that notice of objection at first would have ultimately delayed the administration of the state, but that's what needed to happen in order to make sure that the deceased true testamentary instructions were being implemented.
Great. It's an interesting one.
Absolutely.
And I thank you, Megan. That concludes
Thank
our
you.
podcast. We want to thank you all for listening. I'm Nick Esterbauer.
And I'm Megan Zanette.
Should you have any questions, please send us an email at info@hollandhull.com or contact us through the contact page of our website. Thanks.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.